Dear learners, we shall be starting with the lecture on incoming and outgoing partners. So, in our previous lectures on the law of partnership, we have already looked at how the partners are key essential of the partnership business, and without any persons being partners, the partnership business cannot come into existence and cannot conduct its business operations. So we have also looked at in the previous lectures the kinds of partners and the kinds of partnerships. But in this lecture, we shall be looking at how the partners get into the partnership firm and how they exit the partnership firm. So the word incoming will be used for how the partners enter the business, and outgoing partners will be used for how do they retire or get expulsion or by death. In a way, how do they get excluded from the business or how do they exit the business? So, looking at the legal framework that governs the incoming and outgoing partners, it is specifically mentioned in Chapter 5 of the Indian Partnership Act 1932. The Chapter 5 is titled as Incoming and Outgoing Partners and is spread over Section 31 to Section 38. Now, I have given a brief description of what the each section of this chapter relates to. So, we have the opening section 31, which introduces to us the introduction of a partner, section 32, retirement of a partner, section 33, expulsion of a partner. What is the difference between retirement and expulsion? They are two different modes as to how a partner gets exited from the partnership firm. Then we have section 34 as to how a partner can exit the firm through insolvency. Section 35, what happens to liability of estate of a deceased partner, what is the liability of the deceased partner's estate towards the business of the partnership firm, if any. Then we have section 36, where there are certain rights of outgoing partners, such as to carry on business which may compete with the business of the firm in which they were earlier as partners. We have section 37, the right of outgoing partner to share subsequent profits. Then section 38, revocation of continuing guarantee by change in firm. So we'll be looking at the major provisions of this chapter 5, which shall inform our discussion on incoming and outgoing partners. We shall also be looking at some principles of law as well as some case laws, examples and illustrations in order to have a holistic understanding of this topic. So we shall first begin with incoming partners, which starts with section 31, which is titled as Introduction of a Partner. So some of the keywords of this provision I have highlighted here for your benefit. So section 31 reads as subject to contract between the partners and to the provisions of section 30, which relate to the admission of a minor to the benefits of a partnership firm. No person shall be introduced as a partner into a firm without the consent of all existing partners. So section 31 is a kind of a default law, and this default law or a rule of thumb talks about consent of all existing partners. So the word all here signifies a degree of unanimity that all partners should be on board if they have to introduce any new partner. However, this default rule of unanimity is subject to two things. Firstly, subject to contract between the partners, and the second thing is provisions of section 30, that is admission of a minor. Now, what is section 30 related to admission of a minor? It is dealt with under a separate lecture, minors agreement. So please refer to that. So if we have to break down this section 31, then the modes of introduction, they could be classified under the following heads. So firstly, a partner may be introduced in the partnership firm with the consent of all partners as the default rule. The second is that this default rule may be modified or may be varied in accordance with the agreement between the partners. So therefore, it is possible that the partners in the partnership deed, they decide that if there is any dispute with regard to the admission of a new partner, then it shall be decided according to the rule of majority. So for example, if in a partnership firm there are a total of 7 partners, and in these 7 partners, 5 agree and 2 disagree, then if there is a rule of majority, a new partner can be introduced. However, if there is a rule of unanimity, that is the consent of all partners, then it is not possible for the partners to admit a new partner, even if there is one veto by any of the partner. Then the third way by which a partner may be admitted is according to section 30, that if there is a minor who is initially admitted to the benefits of the partnership business, and later on, upon obtaining the age of majority, there is a provision that he may choose or elect whether to become a partner or not to become a partner. So broadly speaking, there are these 3 ways as to how a partner may be introduced or how he may enter into the business of the partnership firm. Now we shall be looking at a case regarding a dispute amongst the partners regarding the introduction of a new partner, and how does section 31 that we talked about it operate in cases of disputes and real transactions. So we will be undertaking an examination of the facts of the case. Then on the basis of facts, there is a deduction of what is the dispute or an issue, and then the judgment. So the facts of this case, titled as Bind versus Reed, case of 1902, an English case. The facts are that there are 4 partners, A, B, C and D. Their partnership deed authorized A, that is one of the partners, to admit his son X into the partnership on attaining the age of 21 years. Accordingly, when X attained the age of 21 years, A nominated his son as a partner, and X, that is the son, he accepted such nomination. However, other partners refused to recognize X as a partner. So the issue here is that whether X will be legally recognized or considered as a partner in the partnership firm. So going back to our discussion on section 31, it provides the thumb rule of unanimity or the consent of all partners. So here the consent of all partners is not there. However, the agreement that was entered into by the partners, it allowed for a particular way as to how X could be admitted. So he was admitted according to an agreement. So here we are talking about the second mode that we had discussed in the modes for introduction. So accordingly, the judgment in this case was that yes, X will be legally considered as a partner in the partnership firm, because the rule that is contained under section 31, it could be modified or varied by the partners through a provision in the partnership deed which modifies the rule of unanimity, and so X was introduced as a partner in accordance with contract between the partners. Now we will be discussing about the liability of an incoming partner. So when the new partner joins the partnership firm, he gets certain rights, but he also gets certain liabilities. Let us discuss these. So as a general rule, the liability of a incoming or a new partner is prospective. So what it means is that liability arises only for those transactions which have taken place after he has joined the partnership firm as a partner, and not any retrospective liability, that is any liability which was there before he entered the partnership firm. However, this is a default rule which is contained under section 31 clause 2. Section 31 clause 2 reads as, subject to provisions of section 30, that is admission of a minor, a person who is introduced as a partner into a firm does not thereby become liable for any act of the firm done before he became a partner. So for the term before, there is a negative expression, which means he is not liable for any act of the firm which was done before he became a partner. So this rule position is very clear regarding prospective liability. However, it is possible that the partners, through a contract or an agreement amongst themselves, they may vary this rule. So the partners may agree with the new partner that he shall be liable for acts done before his admission, and it may be one of the consideration for the existing partners to bring a new partner into the business on the condition that he is going to accept the liabilities which were contracted by the firm before he became a partner. However, the rule for a minor is different because it is statutorily contained under section 30, which deals with minors agreement in a partnership. So the liability of a minor towards third parties, it does not commence from the date of his becoming a partner, but it relates back to the date of his admission to the benefits of his partnership. So therefore, for the minor, the default rule is that it is retrospective from the date he was admitted to the benefits of the partnership. So therefore, when he eventually becomes a partner, so let's say a person was admitted to the benefits of the partnership at the age of 15 years. So then he acquired the status of a partner at the age of, let's say, 18 years. So if he has elected to become a partner at the age of 18 years, then the 3 years from 15 to 18, all the transactions of the partnership firm, if any liability is created, then that liability would be applicable to this minor for all the 3 years, that is from 15 to 18, notwithstanding that he has become a partner at the age of 18 years. Then we have a case on this point related to the default provision and variation of the default provision. The name of the case is Central Bank of India versus Tasnima Compress Wood Manufacturing Company. We will undertake the same exercise. We will first see the facts of the case. Then on the basis of facts, we shall determine what is the issue, and then we shall deal with the judgment. So the facts of this case are that there were 3 persons, A, B and C, who were partners. They admitted a new partner, that is D, all four partners gave an undertaking that they shall be jointly responsible to the liabilities of the firm to the bank. Later on, D wanted to absolve himself from a loan which was taken before his induction as a partner. So the D wanted to absolve himself from the undertaking that was given, that all the partners shall be jointly responsible. So the issue here is that will D be allowed to absolve himself from this liability? So the rule that we had discussed was that the liability is generally prospective. However, it could be varied by an agreement between the partners to the contrary, thereby making an incoming partner retrospectively liable for the acts of the firm which were undertaken even before he was admitted as a partner. So the judgment in this case was that D will not be allowed to absolve himself from the liability, and as such D would be liable, as his liability is to be determined according to the deed and not according to the default rule that is contained under section 31 clause 2. Now we shall be moving to outgoing partners, or what are the various ways in which the partners may exit being a partner from the partnership firm. So the modes which are there under the law for the partner to cease his partnership or to exit the partnership, broadly speaking, there are four modes. Firstly, it is retirement. The second is expulsion by the other partners. The third is insolvency of a partner, and the fourth, that is the death of a partner. So the provisions regarding the modes of cessation of a partnership of a partner are governed under chapter 5, and specifically we shall be looking at sections 32 to sections 38. Now we shall be discussing each of these modes in some detail. So firstly, we will be taking up section 32, that is retirement of a partner. So a partner may retire firstly with the consent of all other partners. Secondly, in accordance with the agreement between the partners, or in case of a partnership by will, by giving notice to other partners of his intention to retire. So again, the first mode is about the rule of unanimity. The second rule is, which may vary the unanimity through an agreement between the partners. So partners may decide, for example, that instead of the rule of unanimity, there will be the rule of majority which shall apply. Or in case of a partnership by will, so we have already discussed what are the various kinds of partnership. So under that, a partnership by will means that there is no provision for any duration of or determination of partnership. So partners may come in and partners may exit wherever they want, whenever they want. So if there is a partnership by will, they just have to give a notice to the other partners of their intention to retire, and thereafter they may retire from there. So what is the liability of an outgoing partner? So it can be discussed under two heads. Firstly, for any acts which are done before the partner retired. So the rule is that if the liability with regard to the third parties, if it has arisen during the period while a person was a partner, such liability does not end on his retirement, but it continues even after his retirement. So for example, if a person was a partner of a partnership firm, and during the period when he was a partner, a certain loan was taken from a creditor, and the firm has not been able to repay back that loan. So the outgoing partner will be liable for such actions because it was done before his retirement and when he was a partner in the partnership firm. However, this liability may be varied by an agreement between the retirement partner, the existing partners, and the third party, wherein after a partner has exited the partnership firm, he is absolved of all his previous liabilities. This discharge of liability can be done according to section 32 clause 2. So the rule here we have is a kind of a default rule, and the rule contained in section 32 clause 2, it may serve in order to vary the default rule. Then we have for acts which are done after the retirement. So in that case, generally the partner is required to give a notice that he has exited the partnership firm or he has retired to be a partner in the partnership firm and he is no longer a partner. So he is required to give a notice under section 72, which is called as a public notice, which we shall discuss in the next slide. So if no such public notice of retirement is given, then the liability of such a outgoing partner, it continues even after his retirement. But if a public notice has been given, then from the date on which such public notice has been given, his liability ceases to operate. But before the public notice, if any liability is created, the outgoing partner shall be bound by such liability and obligations. So now let us look at the requirement of a public notice under section 72 of the Indian Partnership Act. According to this provision, public notice related to retirement or expulsion of a partner. This public notice can be given to the registrar of firms and has to be published in the official gazette and in at least one vernacular newspaper circulating in the district where the firm to which it relates to has its principal place of business. So there are three requirements of a public notice. Firstly, it is to be given to the registrar of firms, published in the official gazette and in one vernacular newspaper. So therefore, the third parties or the world at large have now are deemed to have got notice, whether they have read it or not, that such a partner has now ceased to be a partner, and so he shall not be liable for any transactions of the firm which are done after the issue of such public notice. Now the second mode of how a partner may exit is expulsion of a partner, which is provided under section 33. Now this expulsion of a partner, uh, it is triggered in certain exceptional cases of very volatile disputes amongst the partners of the partnership firm. So as a matter of general rule, no expulsion is possible unless a power to that effect has been conferred by the contract between the partners. So section 33 reads as a partner may not be expelled. So the word not here is important. A partner may not be expelled from a firm by any majority of the partners except in exercise of good faith of powers conferred by contract between the partners. So a partner may be expelled in accordance with the contract between the partners, but because expulsion is a very major step and may impinge on the right of the partner being excluded, So therefore, the law puts in certain checks and balances, such as requirement of a good faith and the exercise of the powers strictly according to the terms of the contract. Now let us discuss a case related to the expulsion of a partner. The name of the case is Blissett versus Daniel, a very old case of 1853. Nonetheless, it is relevant for the purposes of our discussion. So again, we will briefly discuss the facts of the case, then we will deduce an issue, and then finally we will examine the judgment. So the facts of this case are: there were four persons, A, B, C and D, who were partners in a partnership firm. Their partnership deed authorized two third partners to expel a partner by notice without assigning any reason. Accordingly, A, B and C, that is three partners who were in majority, that is 75% of the partnership composition, they expelled the fourth partner, that is D. Now the reason for their expulsion was not protection of any business or commercial interests of the partnership firm, but because of a personal issue, because D had opposed the appointment of A's son as manager of the firm. So A wanted certain favors from one of the partners which he refused. So the issue was that whether D's expulsion was legal or was it in good faith, because the rule that we had discussed relating to expulsion of a partner requires it to be in good faith. So in this case, the court held that the expulsion was void or it was illegal as it was not taken in good faith. Now, good faith requires that the partners should have the interests of the business and the partnership firm as well as their collective interests in mind, and not for any interests which are personal in nature and not related to the business of the partnership firm. So in a partnership firm, if there are multiple partners, there are bound to be some disagreements. So the mere fact of disagreement does not amount to a bad faith. So some instances of the removal of partners in good faith may be, for example, if any partner is guilty of a criminal offense which may involve a moral turpitude, or if he has been indulging in any misconduct which is detrimental to the partnership business or its reputation or goodwill, or if a partner has indulged in any grave breach of duties towards the other partners as well as the partnership firm. So therefore, this good faith is a very important factor in an expulsion of a partner, and whether the expulsion has been made in good faith or not, at several points it forms the basis of dispute between the parties, which then have to be remedied judicially by a court of law. Now the liability of an expelled partner is provided under section 33 clause 2, which is the same as that of a retired partner. So for the liability of an expelled partner, kindly refer to our recent discussion on the liability of a retired partner. Then we move on to insolvency of a partner, provided under section 34, which reads as: where a partner in a firm is adjudicated and insolvent, meaning thereby he is not able to pay back his debts or his debts exceed his liabilities which shall not be able to balance, then he ceases to be a partner on the date on which such order of adjudication is made, whether or not the firm is thereby dissolved. So when a partner is declared as an insolvent, then it is very detrimental to the partnership firm, So then the other partners may decide whether to carry on the business of the partnership firm or to dissolve the partnership. If the partners do decide to continue the partnership business, then it cannot be continued through an insolvent partner, because this is a statutory requirement of cessation of a partnership on a partner attaining insolvency. Now we shall be looking at the liability of an adjudicated insolvent partner provided under Section 34 Clause 2, which reads as, where under a contract between the partners, the firm is not dissolved by the adjudication of a partner as an insolvent, the estate of a partner so adjudicated is not liable for any act of the firm, and the firm is not liable for any act of the insolvent done after the date on which the order of adjudication is made. So this provision is somewhat different with regards to liability of an outgoing partner as compared to an partner who has retired or the partner who has been uh, excluded or expelled from the partnership. So the difference is that there is no requirement of a public notice as such, and the second is that on the date on which he becomes an insolvent, there is a termination of an agency. So the partnership firm is not liable for any of the actions of the insolvent, and the insolvent is not liable for any actions of the firm. So now we will be moving on to the next mode, which is the death of a partner. So the law does not specifically declare that on the death of a partner, he will be exited from the business, but this is something that is quite natural and has to be understood through a rule of ordinary prudence. Now, death of a partner is provided under Section 35, liability of estate of a deceased partner, where under a contract between the partners, the firm is not dissolved by the death of a partner, that is, the partners choose to continue with the business. The estate of a deceased partner is not liable for any act of the firm which is done after his death. So the legal representatives of the deceased partner are not required to issue any public notice as such. Now we shall be discussing some of the rights of an outgoing partner provided under Section 36. So the rights are that after a partner has exited the business, he can carry on the business like his own business, which may be in competition with the business of his erstwhile firm, and he may also advertise such business. There are certain situations provided under Section 37 where even after a partner has exited the business, he can share these profits which are earned by the firm after his exit. The situation that is provided under Section 37 is, just to simplify it for you, if the business of the firm continues with the property of the outgoing partner even after he has ceased to be a partner, then for the period for which the partnership firm continues to use his property, then for that period he would be entitled to a share of profits. However, there is a bar that is imposed by Section 36, which is that the partners may exclude the outgoing partner from making any use of the firm name which may contain a goodwill, or they may exclude or bar the outgoing partner from representing himself as carrying on the business of the firm. And third, to bar him from soliciting the customers of, and third is to bar him from soliciting the customers who were dealing with the firm before he ceased to be a partner. Then the continuing partners are allowed to impose restraint of trade under Section 36 Clause 2. So a partner may make an agreement with his partners that on ceasing to be a partner, he will not carry on any business similar to that of the firm within a specified period of time or within specified local limits, notwithstanding anything contained under the general rule of the Section 27 under the Indian Contract Act, provided that the restrictions which are contained therein are reasonable restrictions. So, although the contract law under the Indian Contract Act prohibits any restraint of trade clause, however, this is allowed under Section 36 Clause 2 in order to protect the interests of the partnership firm and the continuing partners. So, now we shall be coming towards the closure of this lecture on incoming and outgoing partners. So, we have discussed their legal framework under chapter 5. What are the various modes by which the partners may enter and may exit the partnership firm, and what are the liabilities of incoming partners, the default rule, and how that rule may be varied by an agreement between the partners. So, liabilities have been discussed in the context of incoming and outgoing partners. So, with this, we end this lecture on introduction and exit of partners. Thank you very much.